that you joined our training on Rule 74 Counsel. So I'm going to immediately leave the floor to Melissa Beaulieu, who's going to address the English group by doing a short presentation on the preliminary matters concerning what you need to know, the do's and the don't of Rule 74 Counsel. And Dignité Bouisa will do the same with the French group. And then after their presentation, you're going to be assigned to further breakout rooms to be able to do some practical exercise with the two witnesses that you received in your packages. So we'll start with the presentation, and then each one of you can ask questions after the presentation, and then we'll do the practical exercise.
Yep, just 2 seconds, Mylène, whilst I put the French into their separate group. Mylène, are you just able to explain in French? For the French, you're going to go into a separate group now.
Of course. Alors, bienvenue à tous au nom du comité, du Training Committee de l'ABCPI à cette formation sur l'avocat règle 74 qui représente normalement les témoins qui risquent de s'incriminer devant la Chambre. Alors, la façon dont ça va se produire, c'est que Dignité Bouisa va vous faire une présentation en français sur ce que vous devez faire, ce que vous ne devez pas faire, ce que vous devez savoir lorsque vous êtes assigné comme conseil d'un témoin devant la cour. Et puis ensuite, il y aura une période de questions que vous pourrez adresser à Dignité et à Cyril Lauchi qui seront dans le groupe francophone. Et une fois la présentation et les questions terminées, vous serez amené avec Anta Guissé à faire un exercice pratique avec les deux témoins qui vous ont, les deux déclarations, les deux témoins qui ont été envoyés par courriel au groupe francophone.
Yeah, we should just have the English left in this room now, Mylène.
Thank you, Dominic. So I'll leave the floor to Melissa.
Thank you. Do you have I have a PowerPoint presentation, and we can send it to you after we're finished. Hi everyone. I'm Melissa. I work in defense at the courts, and it's really a privilege to address you today about what is a duty counsel rule 74. If you are on the list, then you might be called on to act as duty counsel rule 74. And we decided to organize this training because there's not that much guidance to duty counsel, and we thought that it would be good to share with you our experiences and a bit of the jurisprudence that exists. Can you see the PowerPoint?
Yeah.
Yes. Okay. Super.
You just need to enlarge it.
Enlarge it.
Just presentation mode.
You can do.
Do it down on the bottom right. No, you've got rid of.
Yeah. No. I click it.
Yeah. Oh, no, I see it. No, mais
presentation. Just I go next door. Yeah, what this? There you go.
I don't know if you can see it.
So
you don't see it?
You don't see it?
There it again.
Maybe because can we share? Can we share screen?
That's what I did.
That's what you did.
Maybe you need to do it again. Share screen. I know you see there. Share on the top corner.
No, this is for. We're apologize for that. We are in the main session, right?
Yeah.
Content.
I will do it.
If you click there.
A window?
And
Yeah.
then we click on yes and share.
Okay,
Yeah.
so that should work right now.
It is. Just, yeah, click that.
So, okay, fantastic.
But just where you were, go to the bottom next to the minus volume or size. Just go to that symbol there and click on it.
Here?
No, the other side. The little, that's it.
That's what we're doing, so you cannot see it?
We can just see everything around it as well. It's fine. We can see it. It's fine. If you can't do it, it's fine.
Yeah.
We can slide now.
We will be sending it to you
Yeah,
at the end of the
fine.
presentation. So prior to your appointment as a duty counsel, what happens in the courtroom and between the parties is that it could be either the prosecution, the OTP, or the defense team that want to bring a witness to testify in court and can envisage that the witness might self-incriminate if he comes in the court to testify. So it will be the OTP or the defense that will request the appointment of the duty counsel pursuant to Rule 74 to the court, and then the court will consider if the witness might potentially self-incriminate himself, and will grant the request to appoint a duty counsel. It can also come from the chamber that will ask, for instance, the OTP, can you provide us with a list of witnesses that you think will require a duty counsel? And then OTP will file this list, and then the chamber will grant the appointment of the duty counsel. This request is made on the basis of potential of self-incrimination, obviously, because the witness has not testified yet, but we already have met either the prosecution of the defense team, you have met your witness, you might have a prior recorded statement, you have interviewed the witness might have testified in other related cases in the same situation, but other case. So you do this request on the basis of what you know the witness is going to come and testify. And then after the chamber grants this, the appointment of the duty counsel, this is when you will come into play. So, after the chamber says, yes, I think that there's a potential for self-incrimination, we can appoint a duty counsel. And it's the registry, it's called CSS, so the Counsel for Support section, that will look at the list of counsel that you are probably on and will appoint someone. They will contact you and ask, are you available to be in The Hague on those days to represent a witness? It's very important to note, and we will come back to that a bit later, that the duty counsel has to be based in not based in The Hague, but has to travel to The Hague for the purpose of the in-court testimony, and a bit prior, because you need to meet with the witness if the witness has also traveled in The Hague, or you can do it remotely if the testimony is not done viva voce, but is done from a remote location. Then you would be appointed. You could also be appointed if you're providing statement. I think you can
talk about it later.
Yeah, we can talk about it. For instance, I've inserted a filing that was done from the registry, so you can see a little bit how the registry acts. They inform the trial chamber that they have appointed a duty counsel. They inform the chamber that the duty counsel will become the legal advisor of the witness, and the duty counsel will be provided with access to all the relevant material in connection with the case, which include the statements of the witness, a transcript of the interview of the witness, and that this will be done all in a confidential matter. And we will come back on what type of documents you can request in addition to what the registry can foresee. It's very unlikely that the registry will give you all the material that you need or access to all the material that you need, but we will come back to that. And then you will have to take a solemn undertaking that you will be respecting the code of conduct of counsel. Broadly speaking, the role of the duty counsel is to, pursuant to Rule 74, if you look at the rule of procedure and evidence, the Rule 74 is called the self-incrimination by a witness. And this is a rule that is specific to protect a witness, for instance, an insider witness that might be self-incriminating himself, to be able to make a statement without any fear of future prosecution. It's to ensure that he will be able to answer questions that will be put to him by parties without fearing of possible future prosecution, as I just said. And this was done to make sure that we can achieve the search of truth, and that the testimony will be as truthful as it could be. And to make sure that the witness will be forthcoming with his testimony, and since otherwise he could refuse to answer some question that could be incriminating. And we will come back a little bit on assurances, but there's always one exception. It's Article 70 of the statute. Any misconduct or if the witness is lying under oath is obviously not covered by Rule 74. So this is an exception to the type of assurances that a witness can get under Rule 74. As a duty counsel, your responsibility is always to your client. You are not obliged to the prosecution or the defense, the calling party. Your responsibility and your duties are really towards the client, and all your actions and interaction with the witness and the court are always bound by or guided by the code of ethics of counsel of the ICC, which include probably a bit as your domestic bar. For instance, always make sure to all documents that are confidential cannot be disclosed, so all confidentiality issues. Conflict of interest is the same thing. You have to make sure that you don't have any conflict of interest if you have represented someone else in the past in your national jurisdiction. This is something that you need to verify and to think about thoroughly. So as I said, there's a distinction. There will be the appointment decision. So the chamber will issue a decision on the appointment of the duty counsel. And then, but this is not the same thing as a decision for assurances. Because as a duty counsel, you can file many motions, and the assurances are one of the motions that you can file under Rule 74, and we'll come to that right now. This is, I would say, one of the most important requests or motion that you can present to the judges, because this is what can protect your client. Assurances are, for example, and you have example on the PowerPoint, that everything that could be self-incriminatory during the testimony will be kept confidential and will not be disclosed to the public or to any state. So you understand that if your client is coming and is testifying to some actions that he did in the course of the event that could lead to prosecution, it does not want this to be made public and available for his state or any state to take some action against them. So this is one of the main assurances that you can request in your filing. You can also request that your client be provided with assurances that any evidence that will be given by him on matters that could be self-incriminating will remain confidential, will not be disclosed, and will not be used against him in any proceedings under the court's jurisdiction, except obviously for giving false evidence or committing misconduct, which are covered by Article 70 of the statute and are not covered by assurances under Rule 74. And this is really important to explain that to your client. And we'll come back to that when we go into details about what you need to address and explain with your client. So when you are appointed, the first things that you have to do is to have access to the most relevant documents. You need to be able to identify at the outset of your mandate what could be self-incriminatory in order to be able to file this request under Rule 74 to request for assurances for your client. This is done in the form of a filing. This is an official filing that you will be doing to the trial chamber. This cannot be done by email, for instance. You will have to do an official filing. And the trial chamber has discretion to grant those assurances or not to grant the assurances. And they can grant, for instance, general assurances, or they can state that it will be granting assurances really on a case-by-case for a very specific subject. And this is why it's very important that in your filing, you're able to outset every topic to provide really specific topics that you want to be covered by assurances. And you cannot do just a general filing. It's very important that it's very specific. You can base yourself, for instance, to identify those areas of self-incrimination on the prosecution trial brief, for instance, where the prosecution really outline his case, and then you can see on which topic your client is also testifying with the prior recorded statement of your client, and then you can identify the areas where it can be problematic for your client. In the case that those assurances are not granted under Rule 74, but you are still appointed, you're still present with the witness may still invoke its right against self-incrimination. So the witness can always say that you refuse to answer a question because it could incriminate himself. And this is also your duty to assess the witness when a topic of self-incrimination is coming up. When the trial chamber grants those assurances, then the witness will have to answer questions that could be incriminating because they would be covered by assurances. So this is a bit different if the assurances are granted or not. And
it could be a strategical decision then as to whether you ask for assurances. I don't know if you want to comment. So just to add on that point, that it really can be a strategical decision, kind of in consultation with your client, as to whether you actually ask for assurances at the outset. Because if they are unsure, they may want to invoke their right to stay silent throughout their testimony. So it is something that you need to discuss with your client, whether you even, it's not an automatic consideration that you will just ask for assurances. And then I think Melissa's got the rest.
Thank you. Yeah, because obviously, and there's all sorts of problems that can come up. There can always be, for instance, also like a leakage of the testimony, and then if it becomes public, then it's a bit more difficult to retroactively recover what has been the damage from the leakage. So that could also effectively be a strategy that we say no assurances, and then the witness can refuse to answer some questions. So for the filing, CSS will be sending you a template that you can use. The style is a bit free, but there's some elements that you still have to comply. You still have to comply with some criteria with the form, but if you follow the template, usually it's quite self-explanatory, and you can also we have included some jurisprudence in the PowerPoint. You can look at other examples to be guided on what you need to include, and but every counsel has their own style, but it's very important. I would say that we have saw some requests that were not really thorough, that were very vague and general, and it can be rejected, or it's more difficult than for the chamber to assess your request. But it can also still be a strategic position to simply outline some topics that you think could be self-incriminatory without going into details, in order to have a more general assurances than a more case by case, because there's always you're always running the risk that the chamber will say, this we don't see any relevance, we don't see any possibility of self-incrimination, and they could reject some topic, and then in the courtroom the witness won't have any protection and will have to answer the questions that could be problematic for them, that could be self-incriminatory. You can also request disclosure. For instance, I have included, for example, the Said case, where the duty counsel has requested some requested some disclosure of evidence. This can be done on an inter partes basis. You can, when you're appointed, it's either the UDP team or the defense team will reach out to you. If they don't reach out, or you can reach out to them. It's a case-by-case basis. But it's primordial that you establish a contact with the calling party, because you want to discuss with them what is the relevant documents that is important for your client. And if they don't provide you with all the documents that you think you need, then you can do a request for disclosure. You can address the chamber and request access to the evidence that you consider to be relevant. You can, I think we'll come back very shortly to what type of documents you can request and you should have access to. You can also do a request. This is all prior to the witness testimony. You can also do requests for protective measures. Usually this will have been done dealt with by the parties. They will ask for example, that the witness is not identified by its name in court, that it will be only referred to by its pseudonym, or that his face will be distorted and the voice will be distorted. So everything that when you will go into private session, when you're in open session, you cannot identify, the witness will not be identified by someone that is watching the hearing. So usually those requests are done prior to you coming into the mix. But sometimes, for instance, in Alassane, the duty counsel realized that it was not, that everything was still, that the witness has not been granted any protective measure, and in his request for assurances, it did include a request to grant the use of a pseudonym and a face distortion and voice distortion. But this is usually, it will be done, but this is something that in your checklist you would need to look if to make sure that this has been done prior, or if it has not been done, then you can discuss with the party if there's any reason why it has not been done, because that could also be that the witness is fine with his identity to be public. So this is something you can discuss with the calling party before.
If protective measures are granted, it means that any information that may identify the witness will always be in private session. So for example, the name of his relative, or the position he had at the time of the event, or as Melissa said, his name would be replaced by a pseudonym. And this can very well limit any potential leak that we were discussing earlier. So when the witness is granted protective measure, even if there's a leak on in the media, for example, it becomes a little bit more difficult to identify the individual by name.
We spoke about that very briefly, but you need to look out for conflict of interest. This is really a case-by-case basis. It happened in the Ruto and San case, and the court not disqualified, but asked for one of the duty counsel to be withdrawn from one of the witnesses. The duty counsel was representing two witnesses that had potential conflict of interest, or could the duty counsel was a bit vague on what kind of information that it would be passing from one witness to another, and the trial chamber intervened and said there's too many risks of conflict of interest. You can only represent one. So if you want to avoid this kind of situation, it's not that if you represent more than one witness in one case, you necessarily have a conflict of interest, but this is something that you need to keep in mind, that even if you are a professional lawyer, that any potential or appearance of conflict of interest can be raised in front of the court. So in order to avoid that, you should do the work yourself, and to make sure that this will not be brought to the attention of the trial chamber. So we're coming back a little bit backward. What kind of documents do you need to request? The list can go on, and you can, at the beginning, you will identify probably some documents, and then when you start reading, you might see that you need a bit more other documents. So you can always be in contact with the calling party and ask for more evidence to be granted access to you. You will need, for example, the transcript of relevant witnesses that testify in this case or in other related cases. You will need, if your witness has already testified in another case, obviously, you want to have access to this transcript. Some transcripts are obviously confidential. I know that some duty counsel have been granted unredacted version because they are covered by confidentiality agreement. So you can request unredacted version. You can also request the prior recorded statement of your witness. So it means that if your witness has met with the calling party, they might have a written statement. It's not always the case at the ICC. You can just have a witness that will come and testify viva voce, so you won't file any written statement, but it's possible that there's one, and you will ask all the attached document to this witness. And when we call a witness with a written statement, we need to ask the chamber to accept what we call the Rule 68 statement. This is the prior recorded written statement. And the chamber will issue a decision if they grant this statement to be part of the in-court testimony of the witness, your client. So you can also request the calling party to send you their request, because you will understand a bit what the witness will be testifying on, why you understand also why the party is calling this witness. So that can also help you to have a bit more context of how the witness is inserting himself in the narrative of the case. And you can also ask, obviously, for the chamber's decision, so you know what is admitted and what is not admitted, because the chamber can decide that some part of the statement are admitted and some are not, some are rejected. The party might have also some witness interview transcripts, so when they met with the witness, they might have done an audio, they might have done a resume of the witness statement, the thing that they so you will have really a thorough idea of the story of the witness. Obviously, this was not maybe shared with the other party, so this is really important that you keep this information is really confidential and you don't share any information with anyone. You can ask for the in-court protective measure decision, as we have discussed. That will also give you a bit of information about why the witness testimony is sensitive, in which area can be sensitive. You can ask for a summary. The parties are usually asked to file a summary of what we intend the witness to testify on, and any other related pieces of evidence. And the parties usually have an e-binder. This is a binder, a list of documents that we intend to use with the witness. It's either it's both the prosecution and the defense that has to constitute this binder. So if you have this binder, it is very helpful to know what kind of documents would be used, and this is good for you to flag the areas and the documents that could be tricky. So you know that when a party will say, I will now be using this document, Mr. Witness, do you recognize this document, for instance, then you know that you have already flagged it. You know that this is an area that you need to be listening and be more proactive. If this is something that you can ask the party to grant access. If it's difficult, you can also, if they don't agree or if they don't have the mean for a reason, it's really a case-by-case situation, then you can request the chamber to grant you the access, and CMS can help you to access it. And this can be done by email. You don't necessarily need to do an official filing to request the disclosure of evidence, the sharing of evidence with you, or the e-binder, unless then the parties refuses to assist you with that. But usually you can come to an agreement with the parties. And also there's another type of document that you can request during the familiarization session. The calling party can have it's a session that is prior to the in-court testimony, when the witness will review his statement with VWS, the Victim and Witness Unit, if they have a Rule 68 statement, and they can make a modification. They can say, oh, the calling party made a mistake, they didn't understand well what I was saying. This is exactly what I was saying. And this will all be recorded, and this will be shared with the calling party. So this is important that you ask the calling party if there was any modification to the statement in order for you to have the full picture of the witness statements.
The corrections made to the statement is also important because your client, the witness, may very well, in the familiarization process, say, I forgot, but I also participated in such and such an event. And so it's an additional area where he may self-incriminate himself. And all of these documents, whether it's the document the defense will use to cross-examine your client or the prosecution will use, the importance of it is because more often than not, the chamber will not grant general assurances and will ask you as counsel to stand up every time your client might self-incriminate himself, to ask for insurance and to go into private session. So you need to master all these documents because you need to see it coming. So you know when to stand up and say, okay, now can we please go in private session? Can my client be provided with the assurances that whatever he's going to say next will never be shared with the state? Or so that's the importance of receiving all those documents, including any corrections made to his prior statement.
Yeah, so the documents, you will identify yourself by speaking with the parties, the calling party, but you can also identify new other documents when you will be meeting with your client, because you need to meet with the client ideally more than one time, because you really need to explain him so he has a good understanding of what is your role, what is his role, what are his rights, and what area can be self-incriminating in his statements. I'll try to speed up a little bit so you have more time to practice. You need to explain what is the ICC, what is his role as a witness. If your client is a suspect or object to any OTP agreements, you can advise them on the possibility of exposure and the fact that lying could cause them, and since it's not any misconduct or misbehavior or false information are not covered by any assurances, they can end up defendants. So this is something that they need to be made aware of very, very clearly. You have to explain to them the right to remain silent and what is self-incrimination. If you're talking about this attack and you're saying that you participated or you just remain an observer, but you were there, you need to really use your skill and expertise in ICL to explain why everything from their testimony can be self-incriminatory. And then, as we discussed, this is when you can discuss with them what strategy you want to adopt, because you are representing your client, but you're not taking the decision for him. You are you're a legal advisor, so you're there to explain them what are the consequences and what are the pros and cons, but ultimately it's for them to take the decision with your guidance.
Can I just on that, because I do think this is important and I know we're running out of time. Identifying areas of self-incrimination is not just limited to crimes that can be prosecuted at the ICC or domestic, but also think about modes of liability, individual criminal responsibility. And Melissa just touched on it there, and it's really thinking about it. For example, if you have a superior responsibility or a commander, so you have an insider or a foot soldier that comes in, fine, they can be talking about the hierarchy, but in explaining those crimes, they may be responsible as a direct perpetrator, for example, or under a different Article 25(3) mode of liability. So, and you see it often where duty counsel forget that the modes of liability may expand the identification of what can be self-incriminating. So I think just really you have to, and what Mylène was saying earlier about kind of preempting what can be self-incriminating, and you really, as she said, go through the documents, and it's better to go broader than more narrower at the outset.
Because you might very well have in the statement a sentence where he said or she said, I did it because, or I didn't say anything during the meeting, but it was decided to. Even that is self-incriminating. And that's why it's important to look at the modes of liability and to think, I'm not only standing up to protect my client when he's directly perpetrating or he's directly committing a crime. I have to think when he's meeting with co-perpetrators, when he's with others, whether he's superior, whether he's encouraging, whether he's aiding and abetting. Because the modes of liability here are you have to think of them like a big basket where anything you do might be self-incriminating.
I think that this is why having a broader picture and having read, for example, the OTP trial brief, or having read other witness testimony that are talking about your client can give you a really a big idea, a broader idea of how he was involved in the case. Yeah, so we discussed that you need to discuss with your client that if he's granted assurances, then he doesn't get to refuse to answer questions in the courtroom, and this is very important for the duty counsel to explain that to your client and make sure that he understands what are the limits of the assurances and understand that he cannot just go refuse to answer question. It's also your duty to verify national law and to establish what could be potentially incriminating for your client into domestic jurisdiction. And this is important because the assurances are limited to the ICC. And if if you don't ask for assurances for some information that for you are not self-incriminatory under ICC, and then the information comes out, then it could be problematic for your client back home. You can pay special attention if your client is contradicting himself, and you can advise him on that some answers can be self-incriminatory, and the fact that he cannot lie under oath, and you're not there to protect him from that. I think this is.
But be careful with that point, because you're not supposed, when your client is testifying and there's an area of self-incrimination and or your client asks to discuss with his legal advisor, with you, before answering the question, you cannot discuss the substance of his testimony. So you even if you see where the defense is going in cross-examination and you see that there's a potential for contradiction, you cannot discuss the substance. You're there to protect his right under to advise him under Rule 74, but the chamber will repeatedly say that you cannot discuss the substance of what's coming up. You cannot tell him, well, be careful because earlier you said this and now you're going to contradict yourself.
Yeah, that's another thing. Yeah. And you can also, they might be in some cases, preparation sessions were allowed. So it's the calling party that can have a session with the witness, and you can ask to be part of this session so you can see the type of question that will be asked by the counsels. But this was not granted in every case, but you can inquire if it's possible for you to assist.
And you may not by then have the assurance decision. So you should be careful with that as well. Yeah, during preparatory.
Yeah, so just because we're running out of time, this is something that I wanted to say, like in court session, when you are there, you have to know that the judge might not have had time to issue a decision on assurances, so they can do it in the courtroom. They can ask you to plead your motion. So this is something you need to be prepared to do, to stand up and plead your motion. And during this session, you need to be extremely diligent, to listen carefully to the question, and to be ready to stand up and to ask if we can go into closed session. And if you need to meet with your client during, you can have the assistance of VWS, the Victim and Witness Unit, that will assist you with that prior and during the court hearing. And for a more practical information, CSS will send you a very detailed information about how to file, for example, how to have access to a badge, to all your email address, to robes, to how to get inside the court. This will all be CSS that will be assisting you with that. Yeah, be aware that you need to be in The Hague for this testimony, and you will be in charge of your accommodation, transportation, visa. So you need to think about all of this prior. And then your mandate is very limited by your letter of appointment with the dates of your appointment. So this is very limited in time, but be aware that as duty counsel, you should request the transcript after the testimony to make sure that all the statement is well covered by the assurances that were granted, so it's very accurately reflecting what happened in the courtroom, because there might be sometimes problems with transcripts. And the witness, if there's any leakage, the witness can ask for your advice, and then you could, your mandate might have expired, but you still can at least advise them to, you can reach out to the prosecution or the defense, the calling party, to at least inform them, and then they will help you on how to proceed from then. With all this, we will now practice. So ready for practice. I will be staying here with Milan, and we might need questions.
But there's enough time. We've got loads of time. So they have a general question.
Yeah. I was going to say in the separate rooms because the French are waiting.
If they can join now.
Yeah.
Yeah, he's bringing the French.
Yeah.
Melissa, I think you should stop sharing.
Yeah. So unless there's any general question on the presentation, Dominic will now assign you to separate breakout rooms so you can do the practical exercise. Alors, ce que je disais, c'est que à moins que vous ayez des questions générales sur la présentation qui vient d'être faite, Dominique va vous assigner à des breakout rooms, à des
salles de conférence,
des salles de conférence virtuelles distinctes pour faire l'exercice pratique.
Malene, I have a question, if I may, please, James and Elijah. We are obviously going to proceed on the basis that there hasn't been an order granting, in this case, any general assurances for the witnesses. Can I ask this, though? Is it the position that when we rise and request that a particular question not be addressed in open court, the court will not grant, in that instance, a general assurance for the rest of the witness's evidence? We'll have to request it for every single potential issue that may arise.
That's a good question, James. I'll translate it in French and then I'll respond.
Of course.
Alors, James demande si on part du principe que les assurances générales n'ont pas été accordées par la Chambre de première instance à votre client et auquel cas, vous devez donc vous lever à chaque fois qu'il y a un potentiel d'auto-incrimination pour demander des assurances à la Chambre sur la réponse que votre client va donner. So the answer is yes. So the Chamber granted legal advisor, you, to the client. So you're in court and you have to, every time you see a potential of self-incrimination, of area where you need to protect your client's interest, you have to rise and ask. And this happens quite often. where the chamber refuses to grant general assurances and wants to do it on a case-by-case basis. Alors, la réponse en français, c'est qu'en fait, plus souvent qu'autrement, les chambres de première instance vont rejeter la requête sur des assurances générales, bien que vous avez indiqué dans votre requête les zones ou les sujets où votre client peut s'incriminer, et va vous demander, et va indiquer dans la décision qu'elle va traiter des assurances au cas par cas. Et donc, c'est la raison pour laquelle il est hyper important que vous maîtrisiez tous les documents qui vous ont été donnés, parce que vous devez anticiper à chaque fois que le conseil, le procureur ou la défense pose des questions sur un sujet en particulier, que vous savez que votre client va maintenant entrer dans un sujet où il va s'incriminer. Vous devez vous lever et dire à la chambre, je vais aller en session huis clos, je veux que des assurances soient données à mon client. Et souvent, les chambres vont le faire au cas par cas.
That's very helpful. Thank you.
No more questions. Okay, so if there's no more question, then we can separate.
Yep, I'll open the rooms now.